Too often, people provide detailed instructions in their will and they don't give enough thought to who's going to carry out those instructions. That person is called the executor. When the will is admitted to probate, the probate court appoints the person who is nominated to serve as executor by the terms of the will. As a result of the probate court appointment, the person who is appointed takes on the duty to carry out the instructions contained in the will. That means that the executor takes on the duty to collect the assets of the decedent and to use the assets to pay the bills and expenses, to pay the debts, to deal with taxes, to sell property, and to make the distributions to the beneficiaries as directed in the will. It can be a complicated job. One reason why we like to do these estate planning and estate settlement seminars is so that people can get an understanding of what the executor's job is and they can make a more informed decision about who to appoint as executor. Earlier we talked about trusts and trustees. The job of a trustee is usually related to longer-term management of trust assets. Compare that to the job of the executor, which is more short-term. The job of the executor is to make sense of the puzzle that decedents leave behind and to collect the assets and clear things up, pay the bills and the debts and taxes and the expenses. When that's over, the executor finishes the job of handing the remaining assets over to the beneficiaries. Sometimes the will directs that estate assets are to be handed over to a trustee of a trust. We've talked about trustees and trusts a bit before, so you have a good idea of what that means. The trustee's job is one of management, investment, and keeping in touch with the beneficiaries. The trustee's job might be long-term. Clients often think about naming individuals to serve as trustees, and usually they first look to family members. But not every family member fits the profile of an ideal trustee. Most families are lucky to have even one family member who would fit the profile of an ideal trustee. But if your family does include a person like that, that can be a good choice. Sometimes clients will go through the list of family members and they'll think, I really don't have somebody who knows enough about investing or finding good investment help, or taxes or finding good tax help, or accounting and finding good accounting help. Management of a trust may require all of that type of knowledge and experience. If the client thinks that there is no person quite like that in the family, the client might look to trusted advisors that they've known for a long time. That could include lawyers and accountants. If the clients can't identify suitable trusted advisors to serve as trustee, they start thinking about banks and trust companies. Although clients seem reluctant to select banks and trust companies, that's too bad, because that can be the best choice for many people, because banks and trust companies that are in the business have a good deal of experience and expertise when it comes to the management of assets and investments and keeping track of the beneficiary's needs. Often it makes sense to name a bank or trust company as trustee together with an individual, making them co-trustees, so that the bank or trust company can take care of business matters and the individual can be the one who's more inclined to stay in touch with the personal needs of the beneficiaries. When the client has young children, the appointment of a guardian for the young children is very important. The guardian can be named in the will. Young couples often have trouble agreeing on who should be named as the guardian. That's one reason why they don't get around to preparing wills. But it's much better to name somebody as the guardian than to leave the selection for argument or guesswork after death. The guardian's job is to look after the personal needs of the children, make sure that they have adequate shelter, education, training, health care, and all of those types of things that a parent typically takes care of. And if there are any assets that go to the minor, then the guardian's job also is to take care of the assets. Actually, there can be a guardian of the person of the minor, and there can be guardian of the estate of the minor. And you can name a different person for each of those jobs if that makes sense. Naming guardians for minor children is a very important reason for younger couples to prepare wills.